Good evening. My name is Sister Catherine Ryan. I'm privileged to serve as the Executive Director of Maryville Academy. This is another edition of Children First, which is brought to you by Cable Access Network Television and Maryville Academy. And I am delighted that our guest this evening is Diane Garrity. Welcome, Diane.
Thank you.
I could also have said Professor Diane Garrity from Loyola University, but I'm going to ask Diane to tell us a little bit about what she's doing to teach and make sure that we have a good practice of law. So Diane, would you tell us what you're doing at Loyola?
I will. Since 1993, we have had a program called the Civitas Child Law Center, and our mission is to train law students and others to represent children in their professional lives. And that includes lawyers, judges, but also non-legal professionals, social workers, educators, law enforcement personnel.
So how would someone that's not a lawyer participate in a program at a law school?
Well, increasingly the law intersects with the lives of so many people, including those in the child welfare system, the education system, law enforcement, and people feel who are trying to provide services to those individuals that a better understanding of the law would help them do their job more effectively. And so we have a specially designed set of programs precisely to accomplish that goal.
Great. Well, that's wonderful.
Thank you.
And if I'm going to ask you this later too, but
Okay.
if someone who's listening tonight would be interested in participating in that program, signing up in that program, how would they do that? Would they call someone?
Well, thank you. Loyola University, 312-915-6481 will do the trick.
Well, that's a very easy.
We also have a very good website.
Oh, so they would
Thank
go to
you.
the Loyola
Yeah.
University Law School website.
Yes, thank you.
Loyola University of Chicago. I should be correct,
That's
right?
That's correct.
Great. Would you tell us more about Civitas?
Civitas was begun in 1993 at a time when the medical profession for over a century had recognized that children required specialized medical care because they're not simply miniature adults. But the legal profession had never specialized. And yet children intersect with the legal system all the time, in child welfare cases, in delinquency cases, in medical malpractice cases, in high conflict divorce cases. The list is endless. And so our goal really is to identify and train law students and others who want to serve children and families in their legal lives.
And how has that program been working?
We're very proud of our graduates. We have graduates all over the country who are carrying out that mission.
And I can add that when I was in the Cook County State's Attorney's Office, before I was invited to Maryville, we hired a number of graduates from this program, and they were excellent attorneys, compassionate, and very competent as well.
And for that, we're very grateful.
Well, thank you for preparing the profession. Diane, tell us a little bit about yourself. Where you went to school, how you got involved in all this work.
Well, I'm a classmate of Sister Catherine Ryan at Northwestern Law School. That's where we first met on our first day of law school. Who knew that we would appear on a television show in 2011? I think I came of age in the early 1970s when social justice was an avenue for promoting justice. That's what attracted me about legal education. And it's also the time that children's law came of age. The Supreme Court had decided really the first children's law case in Ray Galt in 1967, and then a series of cases. So kind of grew up together, I guess. And it's something that I've always been interested in and passionate about.
And when did you begin at Loyola University School of Law?
In 1969.
So
you should know that.
But you've been teaching there since?
I see, as a faculty member at Loyola. Well, since dinosaurs roamed the earth, quite a while. Yeah.
Excellent, excellent. So Diane is well accomplished in the field, and she's not going to tell you, but I'm going to tell you that she's the author of quite a number of legal publications, particularly about children and families, as well as some other areas of law. And she's also been recognized by many groups. I'm not going to list all of Diane's awards right now because that would be the entire show. But I would like to tell you that the American Bar Association in 2001 awarded Diane the Livingston Hall Juvenile Justice Award. That is a very important and highly regarded award. Diane also received a Chicago Bar Foundation Award in 2003, the the Leonard J. Schrager Award, which I think you would want to know. And in 2005, she became a laureate of the Illinois State Bar Association Academy of Illinois Lawyers. So, although she has many awards, I'm telling you about three that,
Well, thank
Diane,
you very much.
we congratulate you for this.
Like half as many as Sister Catherine has.
Now, I will also tell you, I want to make sure you all know we are very proud that Diane Garrity is on the Maryville Academy Board of Directors. We are delighted that she's bringing her wisdom and heart to the governance of our organization. And this year, she has been elected as the vice chair of the board. So, Diane, thank you for all your service for our children as
Thank
well.
you.
And the reason that we invited Diane, particularly for this evening's show, is because we have a new United States Supreme Court decision about children, which we're going to get to in just a moment. But first, Diane, perhaps you could help us understand juvenile court in general for problems of juvenile delinquency.
Okay. Your viewers may or may not know that the first juvenile court in the world was established right here in Cook County in 1899. And after its establishment, it became standard in every state in the United States, but really also around the world. And the idea was a specialized court that took into account the fact that children are not adults, that they have unique needs and unique characteristics that the justice system should appropriately respond to. And if it can respond successfully, then that can put these children into lives of productivity and happiness. So that really was and continues to be the mission of the juvenile court. The court has jurisdiction over three categories of children: those who are maltreated, those who are in conflict with the law, and those who, through their behaviors, place themselves in circumstances that may create problems for themselves or others, such as runaways and curfew violators.
And you mentioned the Galt case before. Perhaps you could just give us that piece of history.
Well, the significance of the Galt case was that the Supreme Court for the first time said that the U.S. Constitution and its rights and privileges apply to children and youth as well as to adults. So in that particular case, the question was, what procedural rights should a young person have who's accused of a crime? Prior to that time, it was well established what rights adults have, but the court in that case held that a child, because of the potential for loss of liberty, has many, but not all of the same rights that an adult has, including the right to counsel, the right to privilege against self-incrimination, the right to participate in a trial proceeding in juvenile court.
And that case goes back to the 1960s.
1967, yes.
Young lad from Arizona.
Jerry Galt, a young lad from Arizona.
Now I want to fast forward, if we can, to 2011, and the United States Supreme Court just issued a decision, now using initials instead of names.
That's correct.
Is that a new direction in the courts issuing rulings?
Well, I think it's it is relatively new, but it's also consistent with the evolving idea that children really are different. From the very beginning, the juvenile court has in many ways sought to protect the identity of all children in the court, especially in Illinois, with the idea that if they can be satisfactorily responded to in the court, it protects them, it protects their privacy and their future.
So, Diane, we have JDB.
JDB.
These are the initials, versus the state of North Carolina.
Yes.
Can you tell us about the case?
I can. This case is part of the long legacy of the Supreme Court's opinion in Miranda versus Arizona, where the court held that under our modern police practices, where people are often questioned in situations outside of their normal home and family, where they are taken into custody and then questioned about a crime, that, in the words of the court, that atmosphere is inherently coercive, and that as an antidote to that there needs to be some mechanism to remind people that they have constitutional rights in that setting. And so I think all of your audience is familiar from police procedurals on television, cop shows, the Miranda warnings that before an interrogation begins, if those individuals are in the custody of law enforcement, that they must be given the standard Miranda warnings You have a right to remain silent. You have a right to consult with a lawyer in advance of saying anything, with the standard Miranda warnings. The issue in JDB was whether or not Miranda is required when police question a student in school in a situation in which, in this case, it was a 13-year-old who was questioned by a law enforcement officer as well as school officials about an alleged theft. And he was he was taken out of his class, placed in a closed facility in the school, was not given Miranda warnings, was not given an opportunity to speak with his grandmother, who was his legal guardian, and was essentially told that by the principal, encouraged to speak to the police, not told that he was free to leave, and ultimately made an incriminating statement. So the issue before the Supreme Court, in the opinion that was decided last week, was whether or not the Miranda decision applies in a school setting, and whether or not age could be taken into account in that setting.
Now, if someone listening is a parent or a family member, or if someone listening is working in a school, or if someone listening is in law enforcement, this case is important.
Yes, it is.
And can you help us understand why it's important to the practice of all of these different persons who are working with our children? If I'm a parent, what do I need to know?
Well, I think everybody wants to both ensure the public safety and at the same time protect our constitutional system. So there's a balancing act, and the Supreme Court in Miranda said, if in fact you are in the custody of law enforcement, that we have a blanket rule that's going to be applicable, that these warnings must be given. And then you make a reasoned decision, an informed decision about what is in your best interest. So parents would like to be notified that their children are in these circumstances so they can help them make that decision. Certainly a defense lawyer would like to, who's schooled in the law, would be like to aid the child in making that decision. School officials, I think, are placed in a difficult position when law enforcement is asked to come in and they're not quite sure of what their role should be in this setting. And of course, ultimately, the youth. In this case, it was a 13-year-old special education student, no prior involvement with law enforcement. And ultimately, what the majority of the Supreme Court said was that this is a coercive circumstance, and that Miranda warnings should have, at least at the youth's age, should have been taken into account. The case is then remanded to a lower court to decide whether or not factually he was in custody.
So if someone in law enforcement's listening, they ought to consult with their counsel. Perhaps they should be giving Miranda warnings to a young person if they're interviewing them in this kind of a situation at the school.
This was a case that's consistent with a series of cases that the Supreme Court has decided in the last several years that recognizes really a principle that has been around since the 1600s, and that is that youth really are not as mature as adults. They don't have the same level of experience. They're more susceptible to all kinds of peer pressure as well as other kind of pressures placed upon them, and as a result of that, the law should take that lack of maturity into account. So the majority opinion holds here that law enforcement agents can take age into account in assessing whether or not this is a case where Miranda warnings should be given.
And that's a good lesson for us to know, because we all want to know what the truth is, and if our young people are getting into trouble, we want to help them. At the same time, we want to do it in a way that's consistent with our legal system. Now, you mentioned that this was the majority of the court that said this.
Yeah.
Could you tell us a little bit about what the various decisions were from the justices of the Supreme Court?
Well, like many of our Supreme Court decisions in this era, we sometimes have closely divided opinions, and this was one of those opinions. they don't always follow a predictable pattern, although in this particular case that they did. The dissent in this case was concerned, I think, about the slippery slope of under what circumstances would Miranda have to be given outside the traditional police interrogation room, and beyond that, whether or not police officers would be placed in a difficult position of having to make an individual assessment about each potential suspect or target's subjective characteristics. Are they particularly fragile? Do they have a psychiatric history? The majority's response to that was age is an objective factor, and if you look at a 13-year-old, you know that it's a very young person. And the court then went on to say, and we know that very young people are especially susceptible. That's been part of our jurisprudence for a very long period of time, and increasingly part of our brain research science as well.
So the majority decision, we have 9 justices on the Supreme Court.
We do.
And how many voted for this opinion?
5 voted in favor and 4 voted against.
And so the 4 are the dissent
Yes.
that you were just talking about. They
Yes.
write their own opinion saying why they don't agree with the
Yes.
majority. And so would you say between the majority opinion and the minority opinion or the dissent that all the arguments for and against this were pretty well presented?
I would say that. I think it was everyone who would read the opinion would know what the set of issues were and what the concerns were, both from a majority perspective as well as the dissenting's perspective. In many ways, I don't think that it's a particularly controversial case. It's quite consistent with 2 recent Supreme Court opinions that split exactly the same way, 5-4 opinions, having to do with the abolition of the juvenile death penalty and the decision that it violates cruel and unusual punishment to sentence a young person to life without possibility of any parole ever for a non-homicide case. All 3 of these cases draw on really empirical evidence that's emerged, both scientific and psychological, that validates really what parents have known for a long period of time, and that is children, both biologically, through experience, psychologically, find themselves in very adult settings with non-adult tools.
And you speak also as a mother, as well as Professor Diane Garrity, is that right?
Mother of 4, only one who intercepted with the law at one point. But that's the life of a parent.
That's right. And putting together common sense and the law. It's nice when they're coming together on what we're learning here.
Right.
Now, actually, you mentioned that this is one of 3 cases that seem to be going down the same path from the United States Supreme Court. What difference does it make to us in Illinois, what the United States Supreme Court says? Is this the law in Illinois now?
Well, the Supreme Court's interpretation of the Constitution is the supreme law of the land, and so when the Supreme Court renders a decision such as this, every jurisdiction in the United States must recognize the validity of that constitutional judgment unless the court itself changes its mind or unless there's an amendment to the Constitution, which is a very rare occurrence, only happened 27 times.
Well, thank you.
Yeah.
So this gives us a picture of the recent cases in juvenile delinquency, and you also talked about another area that the juvenile courts work in, which is the area of protecting children from maltreatment.
Yes.
Sometimes referred to as child protection cases.
Yes.
Could you explain that to our viewers as well?
Well, we know that unfortunately too many children, for a variety of reasons, find themselves in circumstances in which their parent or legal guardian is alleged to have maltreated them in some fashion, sometimes physical abuse, sometimes sexual abuse, sometimes other forms of maltreatment. And as part of the state's responsibility to these children, our courts have jurisdiction over those circumstances. And so unless supports can be given that assures the state the safety of those children, they enter our justice system, and you hope that through a set of policies and practices that family can be reunited. In the majority of cases, that happily does happen, but not in all cases.
And in those cases where the child cannot be reunited with the family, then the child is cared for by another family, or indeed sometimes in group homes.
Yes, in the foster care system and the group care system. Increasingly in Illinois, we've really been a leader in asking other family members to take responsibility for those children, because those children have natural bonds with those family members. They come often from the same cultural, religious, and other traditions that disrupt the child's life more than being placed in a completely strange setting for them.
Now, there's another aspect of child protection cases which relates to termination of parental rights. Can you tell us what that means?
Sometimes this is referred to as the death penalty for families, and this is the last procedural step when all efforts at reuniting this family, at improving a parent's ability to parent a child successfully, have been tried and have failed. Then the final step in the process is termination of parental rights. And in order for that to happen, there has to be a finding that a parent is legally unfit, according to a set of statutory definitions, and that it's in the child's best interest that legal relationship between parent and child is brought to an end. And if ultimately that decision is made, it's as if the child and the parent were never one in the eyes of the law. The consequence of that is that the child then becomes freed for alternatives, most particularly adoption by another family, so that the child can become part of a new family.
And I think you were saying that in most cases this isn't what happens.
That's correct.
This is termination of parental rights is a very severe step when other less serious options fail.
Yes. And the reason that it's so severe is that it really, once rendered asunder, cannot be put back together.
Mm-hmm. A sad outcome,
Yeah.
Except that for some children it becomes necessary to protect them, I think. Now, in your program, I'm going to take you back to Civitas. How do you prepare law students to serve in a juvenile court, or to help children in either the delinquency side, which you described before, or the child protection side that you've just been describing now?
Well, we try to prepare them in three different ways. One, just through learning about the law as it affects children, and there's an increasingly large body of law. Mm-hmm. Secondly, the actual practice of law. So we have clinical and other types of externship programs that permit hands-on opportunities to see the system in operation, work with other lawyers and others in the justice system. And then finally, there's a whole set of ethical issues associated with working for children that we try to acquaint our students with. Again, they're not miniature adults. They don't have the same linguistic skills, the ability to understand their lawyer, their options, their roles. One might think that this is a challenge in working with law students, because by and large, law students obviously are of a different age than their clients. Very often they have a different experience, a different set of background. And yet what we find is that our law students are hungry to take the skills that they're developing in these programs and apply them in a way that promotes justice, promotes the well-being of children.
So that one more time, perhaps the phone number, in case any of our viewers are interested in coming to Loyola?
312-915-6481, and Loyola's website for Loyola University Chicago School of Law, www.luc.edu. We have a new program for non-legal professionals.
Please.
That will be an online program beginning in August. And if you're a social worker, educator, law enforcement official, this is a program that's designed specifically for you with leadership as its principal objective.
Well, thank you, Professor Diane Garrity, for being with us
Thank you,
tonight.
sister.
And I think you can tell why we invited Professor Diane Garrity to be here this evening with her vast knowledge and heart for our children and their families and some of the issues they're facing. So thank you very much. Again, this is Children First, and it's presented by Cable Access Network Television and Maryville Academy. Good evening.